January 6 defendant Edward Lang submits a petition for a writ of certiorari to the Supreme Court of the United States. And if he's victorious on this, it's going to cause a lot of consequences, good consequences, for many J6 defendants who have been improperly charged after the January 6 riots. For some background, let's go over to Newsweek. They say that this case could upend hundreds of Capitol riot cases. It says a new petition in the Supreme Court, the one that we are going to read, could upend hundreds of cases related to the January 6 Capitol riots. Edward Lang, the man who brought this case, was arrested, charged for his role in the riot after he posted photos and videos on social media placing him at the Capitol. The charge in question against Lang and others has been deployed against hundreds of defendants, including QAnon shaman Jacob Chansley, the Oath Keepers founder Stuart Rhodes, former Olympic swimmer Cleet Keller, and others. The charge was also cited by the House committee investigating the riot that issued criminal referrals against Donald Trump. The official proceeding refers to Congress's certification of the Electoral College votes that elected Joe Biden. And so let's take a look at this. It's a little bit of a technical case, but I think we'll be able to get through it relatively quickly. This one goes to the Supreme Court of the United States of America, Edward Lang versus the USA. This case is brought by Norman Pattis. We've heard of him before. We heard from him in the Proud Boys trial, along with Stephen Metcalf, also from the Proud Boys trial. Here's what they are asking the Supreme Court. They say, "Dear SCOTUS, we've got a question about whether the Court of Appeals entered an erroneous ruling. They concluded that the law, which is 18 U.S. Code 1512, which is a statute that was written, it's a criminal law that prevents tampering of evidence. They're asking, does that law that prevents tampering of evidence, can you use that to prosecute violent riots? Are you allowed to do that, resulting in a misapplication of the statute? Can you use like a shoplifting statute for car theft? Yeah, they're kind of the same, like it's something sort of, but are they close enough, or should you use the car theft statute and the shoplifting statute? So they're saying that there's a misapplication here. The DOJ is using a broad application of this law so that they can do whatever they want under it and get a boatload of new charges under this provision, section 1512C2. So they're asking the Supreme Court to clarify this for us. They say that the Fifth Amendment to the United States Constitution says the following: no person shall be deprived of life, liberty, or property without due process of law. And another provision of the law, which is not in the Constitution, but which is in the U.S. Code, says the following: it is illegal that whoever corruptly alters or destroys or mutilates or conceals a record or a document or attempts to do so with the intent to impair the integrity of that document or its availability for use in an official proceeding. That's part one. If you do that, you broke the law, all right? Or you could do this. You could do one or the other. If you corruptly alter or destroy a document and impair that document's ability to use in an official proceeding, guilty. So we're asking ourselves, is attacking a police officer impairing an object's document so that the document is not available for a proceeding? Doesn't seem right. Or how about this one? Another provision of the same law says, whoever corruptly, otherwise obstructs, influences, impedes any official proceeding or attempts to do so. Well, that might be closer. If you're a J6 insurrectionist and you're impeding any official proceeding or attempts to do so, maybe that one fits. So we see the statement of the case. This is the defense writing. In the appeal to the Supreme Court, they say, a short walk from the building in which this court sits, a revolution is underway, with ambitious federal prosecutors reworking the criminal code to make it do work never intended to be done. Work that threatens to chill, and does chill, ordinary Americans in their First Amendment rights to assemble, to petition for a redress of grievances, and to speak out on matters of public concern. These attorneys say, in the name of saving democracy, prosecutors are undermining the core principles on which this republic stands. In this case, likely the first writ of certiorari filed incident to a criminal prosecution arising from the events of J6. The petitioner requests relief to check the blind ambition of federal prosecutors. Stop those prosecutors from doing this, Judge. Without action from this Supreme Court, hundreds, if not thousands, of Americans will face substantial prison sentences for doing no more than speaking out at a protest that evolved into a dynamic conflict. It is no overstatement, Supreme Court, to say that the future of the First Amendment hangs in the balance. A statute intended to combat financial fraud has been transformed into a blatant political instrument. to crush dissent. The attorneys say, on January 6, 2021, thousands of Americans gathered in D.C. to protest a stolen election as direct a threat to our democratic traditions as a foreign invasion. They were inspired to attend and to protest by the President of the United States, Donald Trump, who in the aftermath of 2020 contended the election was stolen to the benefit of then President-elect Joe Biden. Mr. Trump urged people to come to D.C. to, quote, stop the steal. It was the day Congress that was statutorily obliged to certify the results of the vote. When it became apparent that Mike Pence, not my concern, the presiding officer of the joint session of Congress responsible for certifying the results, would not act to stop the certification, Mr. Trump urged thousands milling about on Washington's Mall and at the Ellipse, where the president was speaking, to head to the Capitol and to patriotically and peacefully protest and to, quote, fight like hell, lest they no longer have a country. The president told people the republic was under attack and that ordinary people needed to save it. And so the petitioner, Mr. Lang, sitting in custody, he heeded the president's call to action. He went to the Capitol to protest. He was swept up in the violence of the crowd and the ensuing struggle with the police officers, where he acted to defend himself and others from police violence. He is among the more than 1,000 persons to be arrested in the wake of the riot at the Capitol that day. And he acted in self-defense, in defense of others, and in the defense of democracy itself. Among the charges he faces is a violation of U.S. code. They say he acted with, quote, corrupt purpose to impede an official proceeding. The DOJ promises as many as 1,000 more prosecutions coming. 1,000 done, 1,000 more to come. Still an embarrassingly low number for all of these resources. Save that for a later conversation. This statute has been used repeatedly in these prosecutions of those accused of breaking the law on J6. So they ask the Supreme Court, they'd say, Your Honors, use of a statute intended to combat alteration of records, intimidation of witnesses, and conduct aimed at disrupting proceedings is an example of prosecutorial overcharging, using a statute that was designed for one purpose in a manner at odds and inconsistent with the congressional intent and the plain meaning of the statute. This is a documents crime, not an insurrection crime. So you're not allowed to use it as an insurrection crime. This use necessarily chills anyone considering a public protest or appearing outside a building where there's an official proceeding. Will they also show up and be charged with a felony if the event turns violent, they ask? So they tell us that Mr. Lang originally filed a motion to dismiss this one count. He wanted that one count gone. And you know what? Mr. Lang won on that. The lowest level court, the district court, actually granted the motion. And so the government said, what? They appealed it, took it up to the Court of Appeals, and they issued a split decision. They reversed the district court. Lower level court says, yeah, government can't do this, okay? They're charging you with a protest crime under a document crime statute. The statute is not written for that. You can't do that. So the government appealed it, as they always do, and the Court of Appeals reversed. But they issued a very strange opinion. Mr. Lang now asks this court to grant certification because there's a very complicated question here. And this question is going to arise in hundreds of cases as the DOJ continues to charge folks who participated in a protest turned violent. And resolution of this question is imperative to prevent the use of this statute to prosecute folks who protest in a good faith belief that their actions were necessary to prevent the election from being stolen. An event tantamount to an internal coup d'etat. Refusal to resolve this question will chill others inclined to petition and assemble for a redress of grievances, and for fear that those opposed to their views might prosecute them for this, possessing a corrupt intent. Here's the argument. They say, hey, Supreme Court, prior to the trial, the district court actually granted the defendant Lang's motion to dismiss. The government appealed it and they reversed. And so the sole issue right now, Supreme Court, is whether the indictment that Mr. Lang is facing and the crime under which he has been charged, whether it violates what is called the breathtaking standard under Van Buren versus United States. Two questions. One, whether the law is subject to an evidence-based interpretation, saying, in other words, does the assault on a police officer match the statute? Can we just look at the evidence and does it match? We're going to ask that question and do some analysis on it. Did Mr. Lang's conduct look like it was impeding a document? And second, whether the corrupt element applies. What does corrupt mean? almost means like getting a benefit for yourself. You're going to sign this document so the money goes into your bank account, right? Or something. And the question is, did Mr. Lang have a corrupt purpose? Can that be satisfied if Mr. Lang didn't get anything from the misconduct? He says no, it cannot be satisfied. So those laws don't apply to me. It's not an actual document crime, and I didn't do it corruptly. It was a protest. And when this got to the Court of Appeals, they offered vastly different opinions. So they say, we don't even know what the standard is. We had different interpretations here. Writing for the court, Judge Pan read the section very broadly. He concluded that corrupt mental state encompasses any unlawful purpose. All right, so anything that you do is corrupt if it's unlawful because you're breaking the law. And they say, wait, well, that basically means the statute, like that word would be meaningless then. If it's any violation of the law, it almost sounds like it's kind of strict liability type of a crime. If you just do this thing, you're guilty. But the mens rea, the mental state, is corrupt. So were the January 6ers, in this case Lang, was he acting with a corrupt purpose? There was another concurrence. Judge Walker said something different. Concluded by reasoning saying that the benefit was to President Trump. And so another judge thought it necessary to define corruptly. Okay, so they're all defining corruptly. There was another person in a dissent. And so we've got all these disagreements. Nobody really knows what the application is. So they are asking the Supreme Court for clarity on this. This is an issue of vital importance. If not hundreds of defendants who are being prosecuted here, we're all left without guidance from a fractured court. The judge writes for the court, says there's a broad definition of corruptly, which means any unlawful purpose, and rejects evidence-based limitations on prosecutions. But Judge Walker implicitly rejected that, but adopts a narrower definition of corruptly, one in which there is an unlawful benefit. And then Judge Katsas adopts another limitation, and he says, look, this is a cacophonous result, and it leaves unsettled very significant issues, which is why, Supreme Court, we need you to get in here. If you don't get in here, there's going to be a discordant series of appeals and petitions to come. Everybody's going to be appealing this. It's going to be a total nightmare. So Supreme Court, you've got to hear this. They say this prosecution at issue here arose in unique context and at a fraught moment in American history. A sitting president claimed an election had been stolen. Short of an invasion by a foreign power, the most shocking threat conceivable to the American Republic. The president called upon Americans to come stop the steal. On January 6th, the day the votes count, thousands showed up. But a riot broke out. Hundreds, perhaps when all the charges that can be filed have been filed, thousands of Americans are going to face criminal prosecution on this. All attended an event to petition for a redress of grievances. All assembled, all intended by their presence to speak out. That's what they were there to do. That is lawful. That is not acting with corrupt purpose. That is a constitutionally protected right. A wide variety of criminal charges, both misdemeanor and felony, cover the panoply of offenses committed that day. But for reasons unknown, the Department of Justice has seen fit to apply a statute applicable to crimes involved in the presentation of evidence at official proceedings done for venal and corrupt purposes in a manner that has never been done before. And so it falls on this Supreme Court to rein in the Department of Justice. The deterrent effect of criminal prosecutions must not give way to vindictiveness. Using this law in this manner and in this context will serve only to chill people in the exercise of their rights, the rights that are fundamental to our way of life. They talk about the law again and the judge's dissent. They say the government in this case has made a policy decision to broaden the application of the statute. They want to over-penalize those who participated on January 6th. Until the prosecutions from J6, it was uniformly treated this law as evidence impairment crime. But until J6, courts had no occasions to consider whether they could use this more broadly. And they did, because they want this thing to sting. They want Stuart Rhodes, who got 18 years, to serve much more time. They say in this case, Supremes, protesters turned out en masse to engage in a protected activity. They petitioned for a redress of grievances, they assembled, and some engaged in vitriolic, hyperbolic speech, both on the day of the protest and in the weeks preceding it. When the demonstration turned into a riot, some of the protesters turned to violence. Mr. Lang will contend at trial his use of force was in defense of himself and others from the police violence. There was no need to create a new and novel application of a statute to capture the violence that took place that day. Existing statutes took place, and they are sufficient for criminal liability. Did Mr. Lang assault a police officer? If so, there's a statute for that. Did he breach the peace? If so, there's a statute for that. Did he trespass? The answer is by now obvious. There's a statute for that. It's like the app meme. They should use the correct statutes to prosecute people. They shouldn't be overly applying statutes that don't. But unsatisfied with the penalties, they didn't like the penalties. They wanted more crimes. The violation of these statutes might impose the desiring to broadcast a general and more compelling general deterrent message. The government then transformed the law into something well beyond what Congress ever intended. It was for evidentiary proceedings. And this statute not only carries with it a significant penalty, 20 years in prison. That's why they want that one. It sends a chilling message to anyone contemplating attendance at a rally. Don't even think about it. If you show up there, if things go wrong, you could face charges of corruptly obstructing an official proceeding. And they talk now about the corruptly provision. This is more than mere intent. If the term is more than mere surplusage, it's not a surplus, is the point. This is an element of the offense. The word corruptly means something. And so these lower court judges, they skirted the issue. And we need to know what the law means and what the law says in order for the law to be constitutional and apply. He says Lang moved to dismiss the indictment as to this count. He says this statute was applied to him in a breathtakingly overly broad manner. He says the statute is designed and intended to prohibit tampering with evidence, and it doesn't cover a violent assault against the police. The district court agreed, the Court of Appeals didn't, and so now we're asking the Supreme Court to give us some clarity on this. He's going through the other judges' opinions and teasing out the problems. But he concludes, he says, in sum, the government's decision to charge Mr. Lang here is an example of prosecutorial overreaching. The federal statutes were not silent on the claims the government wanted to pursue at trial. The government contends he assaulted police officers and disrupted Congress. Lang contends otherwise, but he understands that his right to present a defense must wait until the time for trial. For the present, he can only ask this court to reverse the Court of Appeals, saying that there must be evidence of this charge and that the corrupt intent just doesn't apply here. Says that it is the regime that stops this, that stops people from petitioning for a redress of grievances, that is a real threat to democracy in America. And so they say, Supremes, this is ripe for you. We need your take on this. This was drafted by Norm Pattis and Stephen Metcalf, both great lawyers. We've covered many of their efforts here on this channel when they were representing the Proud Boys. In that case, they're saying the Supreme Court, there is nothing here that is appropriate. This is nothing less than the weaponization of the penal code to stifle dissent. It sets a terrifying precedent unworthy of this nation's history, and it must be addressed. So the case is Edward Lang in the Supreme Court of the United States, petition for certiorari. We'll see what the Supreme Court does on this. I do think it is something that needs to be addressed one way or the other. And as more of these cases go to trial, we're going to see more appeals on the verdicts. And Section 1512, I think, will come up again. So the Supreme Court may have to resolve this one way or another. We'll see if they pick it up now. And of course, we'll continue to see what happens with Mr. Edward Lang and all of the other J6ers as the prosecutions continue.